Scott?
Good morning, Your Honor.
Good morning.
Mr. Davis. Chris Scott here on behalf of Michael Davis, 23-445 and 23-359. CF, Your Honor, obviously we're set for trial this week. I believe that Mr. Davis would like to address the court.
Mr. Davis?
Yes, sir. Me and my counsel are having some irreconcilable differences, sir, because I can show paper.
What are you getting ready to ask me today?
Sir, I'm ineffective assistant counsel, sir. So we're arguing.
Swear Mr. Davis in, please.
Yes, sir. Do you solemnly swear or affirm testimony about the truth, all truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Davis, are you asking for another attorney today?
Yes, sir, because I have
Go ahead and put your grounds on the record.
I have documentation, sir, where police say they had right here. The police say that they turned evidence in, and I wrote the Bay County evidence custodian, and they said evidence was never turned in. This is exculpatory to my case because my whole case revolved around a phone call that they never had. The officer stated that he turned it in. I can show paperwork where he turned it in, and then he turns around and contradicts it and say he never turned it in. He accidentally ran this conversation over and destroyed it. By the conversation being destroyed, and if I could prove it, if they never destroyed it, sir, I can't impeach him because it's conflict what he's saying. It contradicts what he's saying. It's like if you're blatantly intentionally falsify legal documents, which is like police misconduct, I could prove that there was never a phone call. It wasn't me on the phone call. They executed a search warrant and swatted my car in the middle of the road and came up with some false allegations on the reason why they did all this. Then that he ran the evidence over, Your Honor, is exculpatory for my defense because it shows that it's prejudice. Like my counsel can't represent me. I'm asking him to file a motion for a discovery violation, and he tells me he refused to file a motion for a discovery violation. I asked him for a Richardson hearing. He told me he refused to file a motion for a Richardson hearing. I told him that they have no probable cause to ever stop me from a suppression issue. He refused to file a motion for a suppression issue. The only thing he's telling me is take a deal or go to trial. He hasn't talked to me about no type of defense he would put up in trial. Only thing he's screaming, take a deal, or I can't represent you, and I'm not filing no motion. And I can prove that you ran over evidence that you say you turned in, and there's a law that none of this evidence was ever turned in. So beginning to the end of my case is being prejudiced, and the officer is acting in bad faith because he's intentionally and knowingly falsifying documents and trying to let it come back around and loop it all in and present it in my case, Your Honor. My lawyer won't do nothing for me. He refuses to do any motion to fight, do anything for me. And all we do is bump heads on when I ask him questions and I show him evidence, and everything I show him, sir, he done read is like, and he won't do nothing about it.
Your Honor, it's true that there are inconsistent statements and inconsistencies in the discovery and the evidence. However, Your Honor, in my review of the file, to file any sort of motion per Mr. Davis's wishes would be frivolous and waste the court's time. I've explained to Mr. Davis that, in my opinion, I don't have grounds to file these motions. And I've explained to Mr. Davis the things that he's arguing are good points, but points to be argued at trial. I find no discovery violation, no evidence of any discovery violation, no evidence that any sort of evidence was intentionally mishandled. What Mr. Davis is referring to is that a recorder that had allegedly had a conversation on it was run over by a police car, and that recorder was destroyed. But I find nothing to show that that was done intentionally. We deposed the officer on this, nothing to show that it was done intentionally or with any kind of malicious intent or any reason to give grounds to file a motion, Your Honor. As far as the ineffective assistance, Mr. Davis and I have talked these things through several times, and the conversation, he's right, we have some differences for sure. However, Your Honor, and I think I've explained it to him. He just doesn't like the explanation that I've given him. Thank you, Judge.
I'm gonna deny your motion to remove Mr. Scott as your attorney. I'm satisfied with his response. Just because you don't agree with the tactics of your lawyer does not mean he's ineffective. It does not mean that you're entitled to another lawyer, a court-appointed attorney. So I'm gonna deny your motion at this time.
So you're trying, so
No, sir, I've already made a ruling. And I've explained. No, sir.
we're going through it, and
Davis, that concludes your Here,
But he
that
railroad me like on some Jim Crow all type stuff.
Mr. Davis, that includes your here.
I don't care about that.
Sit down.
You let the man
Mr. Davis,
railroad
that's
me.
enough. I have made my rules.
And Your Honor, I believe we're waiting to see if another case resolves, whether we're going to move forward with trial. Very good. Thank you, Judge.
Mr. Kennesaw, it looks like we're gonna have at least 2, maybe 3 trials this week. I know definitely Wednesday and Friday. Is that correct, Mr. Sullivan? Well, maybe. State of Florida versus, Shamari Lee, case number 23 CF 17353 and 23 CF 2511. Bilson?
So, Your Honor, I filed this motion because the defendant had raised some accusations in the motion I was filing. I do feel that it could possibly create a conflict. The defendant is now stating that he does not want me to withdraw, that he was just upset. When he said those things, I can address just briefly some of the things that he raised, just for the record. I don't take depositions when it's a law enforcement case. I found that it just allows the adverse witnesses that are state agents to get maybe a better cohesive story. So I don't do that as a rule generally. He had raised that issue in the motion. I believe he had raised that I did not give him discovery. He has all of his discovery. I tend to not like to leave discovery at a jail for a long period of time. It can cause issues with other defendants in the jail. So that's one reason I don't prefer to do that. He raised an issue with Mr. Sullivan. I do consider Mr. Sullivan a good professional friend. I'm very honest about that. I think he's fair. If he misconstrued that in some way, that's his issue. I do think it could be a conflict of things that he said and put on the record, but he is indicating that he would like me to proceed as his attorney. I am ready for trial if we do need to go to trial. I've spoken to Mr. Sullivan. We do have a trafficking case that may actually not be proceeding for some issues we've discussed, and we would just be proceeding on the fleeing eluding case. So I'm fine either way. If you think it is, from what I've stated, a conflict that cannot be resolved based on what you filed, Your Honor.
Mr. Lee, I mean, if Mr. Lee is satisfied and he's indicating he's giving me a thumbs up and shaking his head in the affirmative that you want to withdraw any kind of motion?
I'll make an order. Well, do you want to withdraw? I don't know if that was, I think you're trying to do a Nelson here, but I'm not a public defender. So do you want to withdraw your previous pro se motion that was already?
Oh, yes, sir.
Okay. All right, you've withdrawn your.
Now we're tenants withdraw mine, Your Honor.
All right, we need to set this for trial. And Mr. Sullivan, you want to set it for September 30th or?
Realistically, Judge,
Okay.
because Mr. Overstreet's trying a homicide that week, it's not going to be able to be tried that week.
About November 4th, December 2nd?
Either one works for me, Your Honor.
Let's set it for November 4th at 8:30 and October 25th.
October 25th.
October 25th at 9 o'clock for a trial management.
Yes, sir. Yes, Your Honor.